អង្គុយចុះ
The graphic, please be seated.
Veuillez vous asseoir.
The President, the court is now in session. Yesterday's proceeding was up to the points regarding the issues of the request of the parties, and the decisions need to be made by the trial chambers regarding those requests. Yesterday, the trial chamber was up to that point. However, due to the time limit for yesterday's session, and the request was not yet decided yesterday, and today we will discuss that issue again. Those requests regarding the following points. First, the trial chamber noticed the request by the civil party lawyers to present the factual agreements in public in this hearing, which were agreed upon by the co-prosecutors and the defense counsels. The trial chamber will direct the defense counsels, if they have concrete agreements on the facts, then the trial chamber will publish in public at the end of the sessions today on those factual agreements. Second, yesterday there was an attempt to put forward the request, and the trial chamber would bring up those requests in order to clarify on certain of them, and then the trial chamber will note all those requests in order for us to discuss and make decision. Next, the trial chamber will ask the parties whether they have any other additional requests. And I also would like to remind the defense counsels and the civil parties lawyers. For the civil parties, please follow your group order, group 1, 2, 3, and 4, etc. And when you stand up, before you speak, please announce your name and your group to the trial chamber, because the whole trial chamber does not know your names individually. I would like any party who wishes to raise your request or other issues to bring to the attention of the trial chamber so that we can make decision. Thank you.
Good morning, Mr. President. My name is Alain Werner. I'm a co-counsel for co-lawyers, Civil Parties Group 1. And I do have one request for guidance, Mr. President. Mr. President, on the 20th of March 2009, you issued a direction on the scheduling of the trial. And on point 9 of the direction, it was explained or clarified that the evidence will be divided into topics. And you did indicate 7 topics. And then it was further clarified that on each topic, first the accused will be questioned, and then relevant civil parties, and then witnesses, and then experts for each topic. Now, Your Honours, most of the civil parties that for our group will come before this court to talk do not have anything to say on any of those topics. And the reason is that most of them are relatives of people who were detained at S21. So they have nothing to say on M13, S21, Shonek, or the character of the accused. So we would be grateful if, Mr. President, you could clarify the matter for us and tell us when do you intend to call the civil parties. And it is important for us for that reason. We have, in particular, 2 civil parties, E286 and E287, 2 of our civil parties who will come in front of this court and will hopefully address Your Honours. And they do not live in Cambodia. And as a matter of fact, they live quite far away. So, of course, they will need to have advance notice on when they have to come in front of this court. So we would be grateful for such clarification. Those are my submissions. I'm grateful, Your Honour.
Good morning, Mr. President. Good morning, Your Honour. My name is, or perhaps could you also clarify if I should present my name always if I stand up? And I think the chamber should know me. But I can, however, repeat it. My name is Silke Stuczynski. I'm a colleague for civil parties. I would like to make one request that is related to the amendment of the agenda, the scheduling that the chamber has sent. There we have the point of opening statements, and we were notified that the defense will make the opening statement. On Monday, we have learned that also the accused... no?
Speak louder.
Okay. On Monday, we have learned that also the accused wanted to make his opening statement, and he did so yesterday. I would like to make at this point a short introduction. Civil parties are parties to the proceedings. They have the right to participate. What is the meaning of participation? This means, of course, to be physically present. But that cannot be all. The right of participation includes, of course, the right to be heard. And civil parties who heard yesterday the statement of the accused, which was announced to be held only on Monday and then repeated yesterday orally, brought to the civil parties the wish to respond to the accused and to express their concerns and views. I think this is also for a court who emphasizes to bring justice to victims who are here exceptionally the first time in internationalized or international tribunals, parties to the proceedings, that they should be granted the right to respond, the right and the fundamental right also of fair trial to be heard. And I would like to draw your attention to the jurisprudence of the International Criminal Court. In the Lubanga case, the pretrial chamber 1 decided on 22nd of 2006 that victims who are only participants with less rights have the right to be heard, and at all stages, very important, at all stages of the proceedings, if their interests are concerned. They are only participants. They were granted the right, and the pretrial chamber 1 explained the right of participation means, before the International Criminal Court, means that victims as participants are allowed to make an opening statement and a closing statement. That was something that the pretrial chamber expressed, how they understand the participation and what does it mean. Of course, the participation right cannot be limited to be physically present, and it is, of course, not enough to be heard at a later stage of the proceedings when the chamber intends to invite several civil parties, of course not all, and of course the right to participate must be granted and should be granted at every stage of the proceedings, and that means also at the first day when the accused personally addressed the court in his opening statement, and not only as normally scheduled to give comments on the charges like scheduled under point 8 of the agenda, but he made his own opening statement. And I would also like to draw your attention on the fact that bringing justice to victims means also that they could express their view on what do they think about the apologies that the accused expressed yesterday, and that they can express their view on the what he said, that he is a victim of the decay period of the leaders of the Khmer Rouge, and I think this should be in the interest of justice, given an opportunity to civil parties to respond, or their lawyers to respond to the opening statement of the accused, and of course also in general. And so we request to be granted this right to respond to at least to the opening statement of the accused. This is different, not the same request that was submitted around 2 weeks ago, where we asked to get the right to make an opening statement. Now this is an amended request to react and to respond and to perform, to respond to the accused and to perform our right to be heard. And so I ask the Chamber respectfully to decide on this request. Thank you.
The civil party's lawyer. My name is Much Swanari. I'm in the civil party group 3. First, my respect to the President and the judges. I have another request, in addition to the request made by my group. I would like to request to the Chamber for your instructions regarding the list of civil parties which the trial chamber intends to call them for the testimonies. And I would like to know the exact date that each civil party has to appear before the chamber. Thank you. My name is Kung Pisai. I am from the civil party group 1. I would like the chamber to make an observation during the hearing. According to the scheduling for the participants, however, during our discussion, during the hearing, there is an objection, for example, and then there is a protest or objection, and then the judges have to retire for liberation. So it's not consistent with the scheduling already planned. Second, when the lawyers who make the objection, and to that objection, I would like the civil parties lawyers also to respond to that objection. Thank you.
I am Pierre-Olivier Su. I am a lawyer for Civil Party Group 4. Mr. President, Your Honours, I am in complete agreement with what my colleagues have said with regard to the scheduling. We would like to be able to assist our clients appropriately during the hearings. This goes to equality of arms between the defense and the civil parties in particular, following the opening statement that was made yesterday by the accused. Thank you.
The President, is there any additional request? If there is no additional request, the trial chamber would like to ask the defense counsel on the agreements on facts which was mentioned yesterday. So that agreement on facts with the co-prosecutors, do you agree on these particular facts? And if you do, can during the hearing, in summary, however, it is not to be done now. It will be toward the end of today's session, so that you have adequate time to prepare for the agreements on facts.
Mr. Ho. Thank you, Mr. President. Good morning, Mr. President, Your Honors. We filed to the Chamber yesterday the agreement on the facts which we worked on with the co-prosecutors and the accused, and the document that we filed yesterday can in fact be made public. The Chamber has been in possession of this document since yesterday evening after the hearing.
The President, please, Judge Lavange.
Judge Lavange, just to clear up our position, we would like a summary to be presented publicly at the hearing so that the parties and the public can be in the know, and we wish to find out whether you could prepare such a summary before the end of the day's proceedings. Mr. Ho, as my learned friend of the prosecution said yesterday, if we provide such a summary, we should have to read it out for at least 2 hours. I think it might be a little hard to follow, but if the Chamber considers that this is necessary for the public nature of proceedings, we will do so. But I must say that it will necessarily follow the format of the document sent initially by the co-prosecutors. After each paragraph, we will be forced to indicate whether we agree, whether we do not agree, whether we agree in part, whether we do not contest the fact, and I'm afraid this will take a lot of time. But if the Chamber so wishes, we are ready to do so. It will not be a summary as such.
The President, please, the co-prosecutor.
Thank you, Mr. President, Your Honors. Good morning. Indeed, I second the comment. I will, of course, abide by your order, but I don't think it is possible, nor would it be very helpful, at least on the public side, and possibly not that much helpful on the trial chamber side, to have some kind of summary made. As we've said, for example, one of the paragraphs of the closing order on which this agreement of fact is based, and as you were able to see from the documents we sent to you, each of these paragraphs, or a lot of these paragraphs, were subdivided into specific facts that we thought, and obviously the defense concurred because they answered to those specific facts, that we thought an agreement on those specific facts was useful or would be useful to the Chamber. I now realize that perhaps for the sake of efficient use of the Court's time, we may not have been that helpful yesterday to you by suggesting that we simply file into the case file that agreement of facts, which I note again, we forwarded to the defense in January of this year, received the French agreement 2 weeks ago, I believe, and the Khmer version Thursday. So, it says that all the best intentions, etc., etc. Obviously, we are there to assist the Chamber, and if the Chamber feels that it would be best assisted and the record would better reflect, we can indeed read these facts that have been agreed to. It would take probably, I would estimate, about 2 hours of the Court's time. It would certainly clarify for all what the defense position is on each specific relevant facts. At least we submit they are relevant. And if that is indeed the wish of the court, we will of course abide by it, either the defense or us. And again, I apologize if our procedure was not as helpful as it could have been.
The President, the trial chamber would like to ask the civil parties lawyers regarding the agreement on the facts between the co-prosecutors and the defense counsel. Do the civil party lawyers have any comments regarding this agreement on the facts? Do you have listened to an attempt to show the public the factual agreements? However, the co-prosecutors and the defense counsels have their own reasons in presentation of the agreement, and I would like to seek comments from the lawyers of this Group 1, if you have any comments regarding this issue. Thank you.
Your Honors, I'm grateful. Thank you for your request. We have not seen the agreed fact, obviously, and if your question pertains to whether or not we would like this fact to be read out, where concerning our group, we are in your hands. We are indifferent. We are in your hands. I'm grateful, Your Honors.
The President, the lawyers for Group 2, please.
Okay. Your Honors, we have not yet, as my colleague said, received the agreed facts, but for the how to proceed with this, we think it is really time-consuming to read it out in public, and which is repetition, of course, of the indictment that we have heard before yesterday. And we suggest to, if it is filed, to put it on the case file, of course, but not to read it out. And also a summary, from my point of view, does not make sense to summarize these points. That is, I would say, impossible. It should be, if it is made public, then it should be read out. But we prefer that it is attached and put on the case file. Thank you.
The President, please, the lawyers for Group 3.
Thank you, Your Honor. Well, I would like to repeat the request that I presented yesterday, and I feel that there's a bit of reticence here concerning the participants. I think that indeed it would take about 2 hours, but I think that 2 hours is rather a small amount of time in relation to the duration of the hearings that has been scheduled. But I think that it is extremely important, after having heard on the part of heard Duch's confessions, heard his regrets, that we specify in the facts, and the facts that are incriminated, what is indeed from the start of this file as being accepted, as well as the points that are contested. Because even if he's accepting many, many things, if we list them, there are certain points that are contested. I think it's very, very important so that we can make this immediately public in relation to our civil parties, as well as in relation to the public following these hearings. I think that it's very, very important that in the indictment, the material facts that have been brought up by your competence, we should present the facts that are accepted, because I think it's very, very important, because this point is going to concentrate the elements on which there is a disagreement, but this point is also immediately going to shed light on the seriousness and the reality of the facts that are accepted. And I think that this is an essential point, to know as of the start what is accepted, and to know the points that might be contested, And despite everything, when we take the trouble of following these points, we notice that maybe the points that are contested remain important, but however are minor in relation to the points that are accepted. And I think it's an important point that as of the start, that what is no longer contested in relation to these very grave facts, well, that these points are recognized, acknowledged, and that we take points. Because, on the contrary, in a part, and I think that this could lead to difficulty if there's a difference in the acceptance of points between the public and the chamber.